Hi, my name is John Fraser and I'm the Program Director with the Centre for Equality, Rights and Accommodation, and in this video I'm going to be talking to you about how the Human Rights Code applies to rental housing in Ontario. The first thing I want to emphasize about the Human Rights Code is that it's a very important law, in that in fact it has primacy over all other laws in the province unless the contrary is explicitly stated. What that means is that if there's a conflict between the Human Rights Code and another law, such as the Residential Tenancies Act or the Social Housing Reform Act, the Human Rights Code will win out. You also cannot lose your rights under the code. You cannot contract out of your rights or sign them away. You always have those rights. Now, while the Human Rights Code applies to most rental housing and cooperative housing and many condominium housing situations, there are certain housing situations that are not covered under the code. If you are renting a room and sharing either the kitchen or bathroom with the owner or the owner's family, then you're actually not protected under the code. In fact, you're not protected under the Residential Tenancies Act either. So this is a rental housing situation where you have very relatively few rights. The Human Rights Code protects everyone in Ontario from discrimination related to particular personal characteristics. And there is some confusion about what the Human Rights Code protects. It's important to emphasize that the Human Rights Code does not protect all forms of discrimination. It only protects people from discrimination related to the personal characteristics that are set out in the Human Rights Code. And these are referred to as prohibited grounds. They are race, color, ancestry, place of origin, citizenship. These often are another way of saying if you're a recent immigrant or refugee. Your ethnic origin, your religion or creed, your sexual orientation, so if you're gay, lesbian, bisexual, your marital status, if you're single, separated, divorced, living common law, if you have children, or the number of children that you have, your age, and this includes being 16 or 17-year-old and living away from your parents, if you have a mental or physical disability, your sex, or if you're pregnant, and if you are in receipt of public assistance. This is very important because a lot of landlords and a lot of tenants don't realize that you cannot be disadvantaged, denied housing, have extra requirements applied to you because of your source of income, because you are receiving social assistance from Ontario Works or Ontario Disability Support Program, because you're receiving employment insurance or public pension, any type of government assistance. That should not be a factor in determining whether to rent to you or what kind of requirements are applied to you by a landlord. Now, there are some exceptions under the Human Rights Code. Seniors housing that is restricted to people 65 and over is allowed under the Human Rights Code, but it has to be 65 and over. If a place is calling themselves a seniors building, but there are people living there who are 50 or 55, then it's not an exemption under the code, and it could be in violation of the code. In fact, it could be another way of calling it an adults-only building. You're also allowed to have sex-specific accommodation, so accommodation that is limited to men or women, that is allowed, as long as it's not arbitrary, as long as all of the units except the unit that the landlord or the landlord's family is living in are restricted to people of that sex. The Human Rights Code also permits special programs that are set up to alleviate the disadvantage faced by certain groups with respect to accessing housing or retaining housing. So for example, if a nonprofit organization wants to set up housing specifically for Aboriginal people or for single parents or people with disabilities, these will be permitted under the code as special programs. They wouldn't be considered discriminatory or in violation of the code. Now, when we think of discrimination, we tend to think of obvious intentional forms of discrimination where a landlord says, I'm not going to rent to you because you have children. Or they say, oh no, you're too young. I've had, young people are going to destroy the place. You're going to party all the time. You're not going to pay your rent. Or if a landlord says, I've had problems with people on social assistance in the past, so I'm not going to rent to you if you're receiving Ontario Works. Those are obvious forms of discrimination. They're likely intentional. But the Human Rights Code also protects what's called constructive discrimination. And this refers to policies or practices that on their face are neutral, that may apply equally to everyone and not be intentionally discriminatory, but they have a discriminatory impact or effect on groups of people that are protected under the code. So an example of this would be where a landlord is requiring credit, doing a credit check and landlord references checks. Most landlords, particularly larger corporate landlords, will do a credit check and ask for previous landlord references. And if you have bad references, a bad rental history, or if you have bad credit, in most circumstances a landlord can legitimately refuse your tenancy. However, if a landlord has an inflexible rule where you have to have good Canadian credit or landlord references in order to be eligible for the housing, that's a rule which, even though it's applied to everyone and may not on its face be discriminatory, that's a rule that has a discriminatory impact on, for example, recent immigrants and refugees, because they're never going to be able to meet that requirement because they're not going to have Canadian references or Canadian credit when they come to Canada. It's also going to have a discriminatory impact on young people who are renting for the first time. So this is a rule that, if applied inflexibly, can have a discriminatory impact and therefore would be potentially in violation of the Human Rights Code, even though the landlord isn't trying to discriminate necessarily, and even though the rule applies equally to everyone. This raises a fundamental principle of human rights, that same treatment does not necessarily result in equality, and that to achieve equality, you often have to treat people differently. The Human Rights Code also protects tenants and residents from discriminatory harassment. That is, unfair treatment, unwanted comments, harassing behavior based on a prohibited ground or one of those personal characteristics that we talked about earlier. Now, if another resident is harassing you because of your race, your age, because you have children and your children make a normal amount of noise for their age, because of your source of income, if you raise this issue and your concern with the property manager or your landlord, they will actually have a legal obligation to take action to stop the discriminatory harassment you're experiencing. And that's because when you're living somewhere, you have a right to live in an environment that's free of discrimination. Now, it doesn't mean that the landlord necessarily will be able to solve the problem, but they have to take appropriate steps to resolve it. The Human Rights Code also protects people from retaliation or reprisal based on trying to enforce your rights under the code, or help someone else enforce their rights. You have a right under the Human Rights Code to take action to promote and enforce your rights. You have a right to take action to help other people enforce their rights. And landlords, property managers, superintendents cannot do anything, take any action against you for trying to stand up for your rights. Landlords also have to be careful not to post discriminatory advertisements. Discriminatory ads are also illegal under the code. So if they're posting an ad in a newspaper or on a sign in front of their building or in a rental housing magazine, they have to be very careful that what they post is not going to either explicitly exclude groups of people who are protected under the code or make them feel unwelcome. So obviously an ad in viewit.ca online that says no kids, or we only accept Canadian citizens, or you have to be employed, those would be in violation of the Human Rights Code. Landlords also have to be careful, though, that they don't put wording in their ads that make groups of people protected under the code feel unwelcome. So if a landlord's putting something in their ads such as quiet building, suitable for a single or couple, that kind of wording is going to make a family with children feel that they're not welcome there, or that if they put in their application, they're not going to be given a fair shake. They're not going to be given a fair opportunity to rent that apartment. Also, if a landlord puts in something in their ad that says suitable for a professional, that's obviously going to make someone receiving social assistance feel that they're not welcome and that they're not going to be given a fair opportunity to rent the apartment. For the next part of the video, we're going to talk a little bit about some specific types of rental criteria that have either been found to be discriminatory under the code or have the potential to be discriminatory. A lot of these are examples of kind of hidden, subtle types of discrimination, of policies or practices where a landlord may not know that what they're doing is discriminatory, but where that policy has a discriminatory impact on groups protected under the code.
Landlords have the right to verify a prospective tenant's income to determine whether or not there is enough income there to cover rent. However, a landlord shouldn't make assessments as to whether or not they think there's enough money left over after paying the rent to cover other costs such as food, transportation, clothing, etc. That assessment should only be made by the tenant. As well, landlords shouldn't apply minimum income rules or look at rent to income ratios. For example, only accepting tenants with a minimum income of $50,000, or only accepting tenants who would be paying less than 30% of their income on rent. And the reason why landlords shouldn't make income assessments or apply minimum income rules is that essentially they screen out many prospective tenants with low incomes who are protected by the code, such as people receiving social assistance, newcomers, single-parent families, and young people.
There are certain circumstances where a landlord is permitted to request that a prospective tenant provide a cosigner. Some examples of this would be where a prospective tenant has a bad credit history, has a previously bad history of rentals, or has recently been evicted. A landlord, however, is not permitted to do this when the reason for doing so is simply because the prospective tenant is identified under one of the grounds that are protected under the Ontario Human Rights Code. Some examples of this would be that they are a young person, that they are a person that receives social assistance, or that they are a newcomer or immigrant to Canada.
Housing providers should not refuse to rent to families with children on the basis of the number of people in the family, unless by doing so they will be violating municipal overcrowding or health and safety bylaws. Also, they should not prohibit children of different sex from sharing a bedroom. Under the Human Rights Code, landlords are not permitted to require applicants for rental housing who are in receipt of social assistance to provide direct payments of their rent from social services.
A tenant has the right to request a transfer to a different unit when there is a reason related to a prohibited ground under the code. For example, a family of 2 adults and 2 children living in a 2-bedroom apartment. One of the adults is pregnant and they wish to move to a 3-bedroom apartment to accommodate the new baby. The landlord has an obligation under the code based on the prohibited ground family status to provide a transfer in a timely manner. Another example is a single person with a disability living in a 1-bedroom apartment. It has become necessary for them to have a support person move in with them to help with their disability-related needs, and they need a 2-bedroom apartment. The landlord has an obligation under the code based on the prohibited ground disability to provide the transfer in a timely manner.
Landlords and tenants must understand that families with children will make a reasonable level of noise. Children will laugh, cry, play with toys, and other such activities. In that regard, landlords must ensure that these families with children do not face eviction, harassment, or any other such forms of discrimination based on reasonable levels of noise.
Not only does the Human Rights Code protect people in Ontario from discrimination related to their housing, it also places positive obligations on landlords to accommodate the particular needs of residents or applicants that relate to a prohibited ground, such as their race, their age, a disability, receipt of public assistance, the fact that they're new to the country. Now, I'm not going to be talking about the duty to accommodate in this video because we actually have a a video specifically dedicated to disability and the duty to accommodate, and I refer you to that video if you'd like more information on this concept. I hope this information in this video has been helpful for you, but definitely if you have any further questions, give us a call or email and we'll help you in any way we can.